Nothing else.
Why?
That's my submission. Allow me. Let me do.
You know, Parliament.
Entry 41 is a direct.
No, that would suffer from a fallacy, you know.
Yeah.
Parliament's legislative authority is untrammeled in.
No, with respect. Your Lordship has held repeatedly.
That's why, as I said earlier, Chief Justice Venkateswaraya called this ragbag legislation. No, when he was referring to the taxing legislation, he says ragbag legislation, which is traceable to a lot of powers which Parliament has, if not anything, 97.
No, with respect. Repeatedly held by your Lordships. Repeatedly, not once. 97 doesn't enter the picture where there is a specific entry in list 2. Repeatedly, that has to be, otherwise, there will be no federalism. If 97 became, as a Lordship put in the ragbag, then there will be no federalism because list will be swallowed up.
There also is a problem with the argument. I'll tell you why. This will apply where there is a specific entry which confers exclusive legislative jurisdiction on the states.
Yes.
All right. So for entry 18 of list 2, land, that is to say land tenure, land revenue, etc. So Parliament cannot exercise power under entry 18.
41, but direct entry.
No, but here what happens is, Parliament has powers over everything.
No, with respect, everything in list 2.
Yes.
Not generally. No, with respect, Parliament becomes the UT in the state list.
Right.
It doesn't mean Parliament starts exercising in the UT powers under some other list. But the whole idea, your Lordship judgment says so.
But Dr. Singhvi, Parliament, even in relation to a UT, can exercise powers under list 1.
Under the entire list 1, it always can. List 2 is available to Parliament. There's no point of having a UT.
Power to set up a public service commission within a UT can be traced to entry 97. The rest of the
entry can't because entry 41 occupies. No, with respect.
Article 248.
Mr. Jain.
Is a residuary power.
Right. The moment, let me. Now,
Article 4 is.
Please appreciate this. Your Lordship is not considering a situation where Parliament chooses to pass a Public Service Commission law for Delhi. Nobody is saying they can't pass.
That's
what my Lord is considering is...
No, we were therefore saying...
that your Lordships cannot have the power of the state, that is the UT legislature, to deal with 41, despite Parliament not having exercised. Now, in that a subsidiary point came in, that where is Parliament's power traceable to? Your Lordships, in fact, formulated the question in one way and then said if there's nothing, it will be 97. There is nothing, is the gap in the reasoning. It is assuming what is sought to be proved. There is something. There is entry 41. No entry can be more direct than 41, your Lordship, the Constitution Bench, have said 10 times.
There are two questions really.
And your Lordship has said...
One, can the Delhi legislature set up a state public service for Delhi? One.
The answer is yes, but your Lordship will go on.
2, assuming that the power is not given to the Delhi state legislature, can it still exercise executive authority over the area?
Answer to both is yes, because the answer is yes in the first case, therefore the answer is yes in the second case. Give me a minute. Just take a concepts are most important in these things, not the minutiae. Take the list 2. It is common ground until you come to 41. There on every item of list 2, Delhi Assembly sitting in Delhi, it is passing laws. Every day it is passing laws, every item of list 2. Forget 1, 2 and 18. I'm not talking of 1, 2 and 18 and 16.
Does the enactment of part 14 take away that power?
That was separate. Allow me to come. A very strange proposition is told to your Lordships. I don't want to deal with it now. That Prem Kumar Jain says part 14 and 312 will apply. In the same chapter, same part, same section, 309 will not apply. It's the most remarkable reading of context in the Constitution. Please leave it aside without coming to that. People forget, my learned friends have forgotten, that Prem Kumar Jain was a part 14, which has both 309 and 312, 3 sections apart. Same chapter. Your Lordship has 1,000 judgments that unless some extraordinary words of the Constitution say your Lordships can't apply X to 312 and Y to 309. But let us leave that aside.
Yeah.
Now, it is common ground that in every entry of list 2, we are suddenly told that without pointing to your lordships any article of the Constitution, you can't do it in 41. Now remember,
Dr. Devi, is there any other entry in list 2?
Yes.
Which conceivably it could be argued is not applicable to a UT?
Exactly. I took your lordships almost 3/4 of the way down.
Right.
I read about 40 entries or 35 entries.
Right.
Well, once your lordships 239 AA chooses to exclude 6 entries, why will your lordships at all go down the path of being told to imagine that some more are impliedly excluded? Well, these are fundamental principles of interpretation.
Or is the word insofar as is applicable really intended to be a word which says with such
mutatis
mutandis?
Well, as I argued with you, well, it is nothing but mutatis mutandis. It fits in perfectly.
So far as may be applicable means
mutatis
mutandis.
Greatest humility.
That's
means intended to mean mutatis mutandis because we are dealing with a sui generis creature. Once your lordship takes that view, it harmonizes everything. Now allow me one more thing. So my lord is today being told that 41 being as it is directly dealing with the subject. I am right here and now saying for the 10th time, if Mr. Mehta chooses to pass a law on 41, your lordship will deal with a different situation. What is the problem? Having not passed a law in 41, having passed no law in 41, why is he going back to 97? Note that judgment, Justice Rumapal put it very well, in that judgment. There are any number, it has to be. Otherwise, if you use a residuary entry to trample over list 2, there will be no federalism left. Now, kindly see that. I'll just give a lot of That brings me to the 4th aspect. You are Parliament. You have admittedly a UT. Well, this is an example of being hoist on your own petard. You have a UT. You have enacted a law, but when faced with the direct of a Public Service Commission for a UT, and your lordship in the opening asked me, UTs include Delhi and non-Delhi. So it can't be a law that UT means different for Delhi and UT means different for Jammu and Kashmir, as far as the concept of UT is concerned. Now, how did you enact a law except under 41? When your lordship put that question, the answer is no, I elected. First of all, there's no answer. Your lordship gave, if I may say so, both sides of the coin. If you did not do under 41, the only power is 97. Because of course, we would not expect. Is itself indicative of the fact that this is how the government of India stand. Not that there is any estoppel here. Nobody is arguing any estoppel in constitutional law. But your lordships can take it. The government of India has never dreamt of 97.
No, but the power is there. There's the constitutional
right.
power is there. Then
now just see 41.
From the judgment in Dillon, it has been always said. For Parliament, you only ask whether there is a subject in list 2. If it's not in list 2, then of course.
Now just see list 2. 41. There cannot be words more directly occupying. State Public Service, semicolon, State Public Service Commission. But there can't be more direct words. Your lordship has held by implication entries to occupy with much lesser words. My lord is absolutely right. Absent 41, you might, I'm not conceding, because I doubt if a government of India, which is given by your lordship's constitutional bench power to act for a UT under list 2, can start acting under list 1. That is another thing. Your lordship constitutional bench makes it clear that the difference between a regular state and a UT is that Parliament can act on list 2 subjects. Now, suddenly you go to 97 on general principles is not allowed. Kindly see the judgment. Give me the citation. 2000,
2005 2SC 669.
Give me the citation. 2005 2SCC 669. Well, these are many judgments. I only brought it up when your lordship suggested 97. I can take out many more in my note.
What, 97?
It's about the residual entry.
2005?
669.
2005, Volume 2, SCC 669, Para 7, Manoj. I'm only on the 90th. I'll give more judgments, Manoj, because this came up right now, that's why. This 97, but logic is not applied, right? Given, right? Because it happened now in the court, so I'm just taking out the right one. Now, let's kindly continue. I'll come back to it. So, my Lord has reached my fourth aspect under this Public Service Commission, the J&K aspect. Well, my fourth point is that J&K is relatable to an exercise of power by Parliament, qua a UT, only and only under Entry 41. That's my humble submission.
Exercisable, relatable to the
exercise of parliamentary power for a UT, qua a State Service Commission, under Entry 41. Now turn to my Para 5, Para 2. Yes. Please do that. Now, Your Lordship can now read with me my submissions, Para 2.
Para
2. Part 14 envisages services of a UT. Lordship, you got that heading?
Yes.
It was argued by the learned solicitor that neither a public service commission for a UT nor a public service of a UT is permissible under scheme of constitution, particularly Part 14. This is clearly incorrect and belied by Parliament's own express understanding. The below provision of the Reorganization Act, these are important, just read with me slowly, demonstrate without any doubt that public service for a UT, as also a public service commission for a UT, are not just permissible, but that Part 14 in fact envisages them. This is apart from Premchand Jain, which I am coming to. I'm reading section 90 of the J&K Act of 2019 is quoted there for convenience. Other provisions, nothing in this section or in 89 shall be deemed to affect on or after the appointed date the operation of the provisions of Chapter 1 of Part 14 of the Constitution in relation to determination of the conditions of services of persons serving in connection with the affairs of the Union or any Union territory. As clear as can be, Part 14. Now continue, Manoj, kindly continue. All services prior to the appointed day rendered by a person, if he is deemed to have been allocated to any Union territory under 89, shall be deemed to have been rendered in connection with the affairs of that UT. Then, if he is deemed to have been allocated to the Union in connection with the administration of the successor UT, shall be deemed to have been rendered in connection with the affairs of the Union. Then, provisions of 89 shall not apply. Now, 91. Provisions as to continuance of officers in same post. Every person who immediately before the appointed day is holding or discharging the duties of any post or of office in connection with the affairs of the existing state of J&K, in any area which on that day falls within one of the successor UTs, shall continue to hold the same post or office in that successor UT, and I underline this, and shall be deemed on and from that day to have been duly appointed to the post or office by the government or other appropriate authority in that successor Union territory. provided that nothing shall be deemed to prevent a competent authority on and from the appointed day from passing in relation any order. Now 93 is very important also. Provisions as to State Public Service Commission. This is Parliament acting in a UT only under 41. The Public Service Commission for the existing state of J&K shall, on and from the appointed day, be the Public Service Commission for the Union Territory of Jammu and Kashmir. If it is insofar as applicable, you can't have the power, then how can you pass this law? This provision can't exist. This provision of a parliamentary law is negated by the Government of India's own argument, if this argument is correct, which I say it is not. Then, Malas, today, please remember, we are not about Parliament's power to pass a similar law as J&K for Delhi. We are about a very remarkable proposition. Absent even an attempt by Parliament to pass a law about Delhi, Mr. Singhvi can't act on that entry 41. That is the proposition your Lordship is addressing. And Manoj, the fact that he can pass a law and I can also pass a law perfectly harmonizes. And if I can pass a law, obviously I have executive power, perfectly harmonizes. Why should your Lordship have to travel beyond 41 to a Central Union Public Service Commission in entry 70? A Union Public Service Commission. Why, Manoj? Why does the Lordship have to travel to 97, which is a residual entry? There is a direct occupation of list 2 by entry 41. Please pay attention to that. Also, Manoj, please note, to complete this point, well, it is because of 246, which your Lordship noted in the pre-afternoon session, that Parliament can act under list 2 at all. Otherwise, Parliament can't just come rampaging into list 2 just because it's a union territory. It is list 2 which, 246 which allows it. So it perfectly harmonized. 246 takes you to list 2. List 2 has got entry 41. Parliament is welcome. I am welcome. No need to go to either entry 70 or entry 97. That harmonizes the entire circle. Now let's see how this is fortified. Your Lordship has read just now part 14 in the Act of J&K reorganization itself. It is mentioned and quoted by me. Now kindly turn to part 14 of the Constitution, textually. Is this interpretation even statable, is my question to myself. Does your Lordship allow it for ordinary contracts or statutes or in any constitutional provision? The interpretation canvassed by the Government of India. Please come to part 14 starting. It starts with 308.
Yes.
In services under the union and the states. So here, just give me a second, Manoj. Himachal and one other state arose in Prem Kumar Jain. Clearly the title is union and states. So simple argument was made, UT is not covered. Lordship sees the title of part 14. Yes. Binary distinction, union one side, state one side, there is no UT. Therefore the High Court in the case of Himachal, held, sorry, out you go, you are a UT, you are not covered. Directly on point, Delhi High Court. And equally directly reversed by 4 judges of your Lordships. Very simple argument, see the title, services under union and states, therefore no UT. Now read below 305. In this part, unless the context requires the expression, state does not include. Now let us come to 309. This is 309. First read 312. 312, no? First read 312. I'm sorry, before that, would my lords note that there is nothing, no special provision which suggests that what will apply to 312 will not apply to 309. Now first start with 312. Go in reverse order first. 312 is even more important. It is all India services. Malas, this is a little important. All India services includes the basic large service, of course, IAS, etc., and AGBUT. Whereas with deepest respect, the government of India, in trying to defend this case willy-nilly on any ground, is killing the AGBUT cadre. The AGBUT cadre cannot exist if this argument is correct. Now read 312. Notwithstanding anything in chapter 6, if the Council of States is declared by resolution supported not less than 2/3, it necessary to expel national parliament.
After Goa becomes a state, now it's clearly the AGBUT cadre covers a state as well as the union territories. Likewise, Mizoram is also a state.
That's right. That's right.
Tripura also.
That they've created, they especially applied that cadre to that. But today, Malas, in fact, need not read it, just see two words, Malas. 3121 is one or more all India services, fourth line. That line alone has to be underlined. In 3121, one or more all India services. And then, Malas, subject to regulate recruitment conditions of service. Then, Malas, number 2, clause 2 talks of IAS and IPS. Let's leave judicial service in number 3, Malas. And 4. 3 and 4 are judicial service. I hope I'm clear. Now come to Prem Kumar Jain. I'm sorry, to complete. See 309 also. 309 actually is more in my favor because it is subject to this constitution, which means it is subject to 239 AA also. 309 opens with the words subject to the entire constitution. Therefore, subject to 239 AA also. In the same chapter, same part, 3 clauses apart. Then read Prem Kumar Jain with me. Subject to the provisions of this constitution, acts of appropriate legislation may regulate the recruitment and conditions of service of persons appointed to public services and posts in connection with the affairs. Provided, the proviso is important for my purposes, last 4 lines of the proviso, where I'll read the whole slowly. Provided that it shall be competent for the president or such person as he may direct in the case of services and posts in connection with the affairs of the union, and for the governor of a state or such person as he may direct in the case of services and posts in connection with the affairs of the state, to make rules regulating the recruitment and the conditions of service of persons appointed. Now mark these words. To such services and posts until provision is made in that behalf by an appropriate legislature. It's a transitional temporary provision. Until provision is made in that behalf by an act of the appropriate legislature and any rules.
Executive legislation.
I beg pardon?
Executive legislation.
Yeah. Executive. Yes, please. Now, nobody is saying that if you choose to act and make a law, you can't do it under entry 41. Question is, having not done it, you are saying the appropriate legislature, Delhi can't do it. Because I apply the entire constitution without an exclusionary article to all the entries of list 2, but I exclude entry 41 by implication. Manas, this is, and remember Manas, the impugned notification is not a statutory, not a constitutional, it's an executive rewrite, adding a 4th clause to 1, 2 and 18. Manas, your lordships have to face that point, Manas. You've got 1, 2 and 18 the constitution gave you, and by an executive impugned order, 2015, you are adding 41 to 1, 2 and 18. Manas, your lordships, with great respect, no canon of interpretation is told to your lordships. Same chapter, Prem Kumar Jain, 3 sections apart will not apply. Now turn to Prem Kumar Jain. Yes. 52. Bookmark 52, page, I'll use yours. Just see para 2, 7 and 8 I read. I'll not read again. Mr. Jain read it also. Exactly the same point Delhi High Court held and reversed by Supreme Court. The state here, or the UT here was Himachal and Delhi. Where is it here? Here, Manas, Delhi and Himachal, joint cadre was involved. A new cadre of service, may I read, Manas, very quickly? 4 learned judges, and Manas, with respect, Mr. Jain may have dealt with it later. It doesn't find mention in Mr. Mehta's submissions. Neither 52 pages nor 90 pages earlier. A new cadre of the service was constituted for the Union Territory of Delhi and Himachal, and recruitment to that cadre was made directly without complying with the requirement of Rule 4.1 of the IAS rules, etc.
I read it. It's part of my volume, and I read it today also.
That's all right. I'm just saying it's not part of your submissions.
Submissions. I read it. It's part of my today's submission. And
now been gone into.
Annexed it and read it. Then already reference.
Read from us fourth line. The rules were amended on December 21 by providing for a joint cadre in relation to the UTs and the Northeast Frontier Agency, and the central government formulated the aforesaid scheme to extend the Delhi-Himachal cadre to all UTs by absorbing the officers of that cadre and by appointing it to officers of the Indian Frontier Administrative Service and all the union territories. The joint cadre for all UTs was brought into existence in 1968 January, hereinafter referred to, skip that. The petitioners in the High Court challenged the creation of the new joint cadre for all the UTs and the appointment of some of the respondents thereto. It was urged in the High Court that the constitution of the new joint cadre was illegal as it was contrary to the provisions of 312. Why was this? One line, simple. As it was not common to the union and state, inasmuch as a UT was not a state. Well, this joint cadre means it has to be government of India and a state, or two states. Now, Himachal is not a state, therefore out you go both the categories. That's a simple argument. Now let us come to 7. My finger is always changing. Now your Lordship will come straight away to para 7, where they compare the provisions, and then come to 8.
Yep.
8 is enough.
58.
It's been read, marked by your Lordships, but just note, directly the contention reversed, he said, fellows, 7th line before the end of the paragraph. The High Court was therefore wrong in taking a contrary view and in holding that UTs are not states for purpose of 312 and the preamble. All that Mr. Jain is saying is that contextually, UTs are states for 312, UTs are not states for 309. That your Lordship decide. Any great article in the Constitution so suggests? Is the subject of 309 Arctic Pole and the subject of 312 Arctic? Is the subject of 309 directly opposite to the subject of 312? Imagine the difficulties that arise if UTs are states for 312, UTs are not states for 309.
What do you have to say about the legislative history argument on part 14 with the SCR?
It's completely unnecessary. Completely unnecessary. Legislative history, Manoj, has been legislative history has been legislative history is completely, it's very good to have all these long submissions with all the details. Very useful to have them. But they have no relevance to the case for the two simple reasons. It is superimposed by 239 AA in 92. It is superimposed by a Lordship General Constitution Bench. And it is interpreted by Prem Kumar Jain, which doesn't find a mention in this legislative history. So, yes, it arose historically because your Lordship knows we had 4 categories of states. We knew we had Raj Pramukhs. That's all very valuable, but it doesn't address the issue. That is, it would have been relevant pre-Prem Kumar Jain. That look, it's a grey area. It's a tabula rasa. Your Lordship has not yet painted on it and decided that UTs under Part 14 are states. Post Prem Kumar Jain, where is the relevance of any history? Because your Lordships were called in only for that reason. Your Lordship had a fight only for that reason before the High Court, which your Lordship resolved. After that, whatever part 3 state was, we know Ajmer and these other states are all there. What is the point of all that? Now, kindly come to some very interesting rules which are not shown to your lordships. The lordship has shown transaction of business rules for almost 1 hour. Kindly see if any of it is remotely relevant after lordship sees 4 rules. I am now in para 3 of my submission. Transaction of business rule only says, generally, what is mine, it is divided like this. What is mine is the operative word. It doesn't say that if I divide it like this, you get what is not yours. But
now, Dr. Singhvi, we got your submission. Now, insofar as the All India services are concerned,
that is the rules now coming up.
Right. We'd like you to
straight away. It's about 4 or 5 rules, and in fact, not even 4, 3 rules and 3 paras of mine. These I need to show to your lordship. Your lordship will see them. It will take 2 minutes to show it. May I read it? May I read it first? Para English 3 months, ordinary 3
months. Yes, let's read that.
Allocation of all India services civil servants in respect of Agmut cadre is done by the Joint Cadre Authority and not the Ministry of Home Affairs. Directly shown to your lordships, Ministry of Home Affairs, that's wrong. It is the Act will apply, then a rule under the Act, then a notification under the rule, or a resolution shown to your lordships. The resolution is shown for a very different purpose. What your lordship is told is under a resolution, MHA looks into it. That was a temporary arrangement. Then there were rules, first Act, Section 3, then Rules 4, and then a notification of 25th April 1995. And it's clear that UT is the state. And one more point before I read it. In all these joint cadres, the whole idea, what is the meaning of joint cadre? My reps exist and act and decide as much as their reps. My chief secretary sits there. Joint cadre is collegiate. It doesn't mean he's excluded, but equally doesn't mean I'm excluded. Now let's kindly come. The Joint Cadre Authority is established under Rule 4, take out the reference, of the All India Joint Cadre Rules of 1972, which are statutory under 3.1. Now the order is the reverse. 3.1 comes first, then comes Rule 4. Section is 3.1, Rule is 4. The authority is a committee comprising representatives of each of the government of states, constituting the joint cadre. The Agmut joint cadre has been established under this rule by notification dated 25/4/95. That's the third one. Act, rule and notification. Whereby Delhi, along with Arunachal, Goa, Mizoram, is represented in the joint cadre authority through its chief secretary, whereas the other union territories are collectively represented by the MHA. This distinction itself is important. Delhi has a chief secretary sitting there. MHA acts for a few other smaller UTs or whatever lordship you call them. The function of the Joint Cadre Authority under the All India Rules of 72, the fourth point was, under Rule 5.1, quote, to determine the names of the members of the All India services who may be required to serve from time to time in connection with affairs of each of the constituent states and the period or periods for which their services shall be available to that government. Just pause here, brothers. Look at the bizarre result which is being canvassed before your lordship. Even at the time of allocation, your lordship knows civil services. I am an officer, brothers, of the central service, or IAS. Cadre is, let's say, whatever, UP. Today, from Delhi, some ministry, I am to be posted. At that time itself, a joint cadre will operate for a UT. Where I am sitting, he is also sitting. Look at the bizarre consequence that after I am posted, even at the time of posting, the chief secretary has a say. But after I am posted, the state of NCT cannot decide whether to post with Mr. Farasat, to post with Mr. Rahul Mehra, post with Mr. Chadda, or to interchange them every 6 years according to whatever, 6 months according to whatever they want. This I am showing given at inception. Now see those rules. First turn to section 3.1. Bookmark 45, page 3949. But with respect, this is actually driving a coach and four through a very well-established harmonious scheme. It's only a question of requiring a lordship's interpretation. Imprimatur, not even interpretation.
3949.
Yes, 3949, bookmark 45. Show me now. Your Lordship saw this briefly, but in view of my learned friend's argument, it's very important to see it. In this, Your Lordship will see, I think rule 4 and 5 is enough. Why does it not go up and down? Do not scroll. You scroll it. Wait.
Yes.
Wait. Let me. Does my Lord have it, please? 3949, All India Services, bracket Joint Cadre Rules of 1972.
Yes.
I want to show 3.1 of the Act. You are not showing 3.1 of the Act.
Yes.
May I just read 3949 on the top? Has my Lord's got it?
Yes.
The title is All India Services Joint Cadre Rules of 1972. It is not disputed that things like AGMAT, etc. are joint cadres. It's not even disputed. In exercise of the powers conferred by 3.1, this comes at the top. Lordship will note 3.1. It's in the file. I'll give you also the page also. It doesn't have to be read. It's Act.
Bookmark 9.
The central government, after consultation with the governments of the states concerned, hereby makes the following rules. Just mark that section is under the All India Services Act of 1951. It is at page 820, bookmark 9. That section 3.1 is 820, bookmark 9.
Yes, below 1 tomorrow. Dr. Singhvi, we don't want to rush you. Are you going to finish today or you will spill over a bit tomorrow?
I don't want to ask Lordship to sit so late. Give me 1 hour tomorrow, I'll finish it off. First, Lordship will assemble here and finish it 1 hour, then Lordship will take your normal.
1 hour more you want?
Well, I don't want to just, Mr. That's very unfair coming from him.
No, not at all.
No, that's a very, I can understand him.
Dr. Singhvi,
My learned friend argued for my entire 150 minutes. 60 minutes became 150 minutes.
And we did honor.
I am taking into account 150 minutes of argument.
Okay, that's why I asked
in 1 hour tomorrow. I'll do it even in 45 minutes tomorrow, first thing in the morning. Constitution bench, I have a problem with it. I can't help it.
Dr. Singhvi will time tomorrow.
I'm very deeply obliged.
Keep it first on board.
Assemble first.
One clarification.
And then our regular boards will start.
I'm very deeply obliged.
Only one,
very deeply obliged.
One clarification. My today's submission may be read in conjunction with the earlier. It's not substitute.
No. Obviously, it's not a supplementary.
Supplementary.
We also thought that Dr. Singhvi, you've made your point. We can also reflect on it. If we have some queries, we can pose you. Otherwise, we will not have the opportunity of posing.
Certainly, certainly.
You can
I may even take lesser than 1 hour.
We can also now sort of
Your Lordship,
reflect on what has been argued and
Deeply obliged.
But would my lords be assembling at 10:30?
Yes, yes.
yeah, we'll take it up at 10:30 only, right? 10:30. Want to do it in
Otherwise, Your Lordship, other benches will be packed.
So we'll keep this matter between 10:30 and 11:30. Then we'll take our mentionings so that my learned brothers and sisters are free for their regular work. And then we'll start with our regular work tomorrow.
Obliged, very, very deeply obliged.
Please. Narasimha and I will come back for the mentioning.
Just
Grateful to you.
1 hour, no? 1 hour.
1 hour.
I will not exceed a minute. Your Lordship, may time me. I am not going to exceed. Certainly.
Yeah.